The Laken Riley Act has given Department of Homeland Security, ICE, the power to detain someone indefinitely while their immigration court case is going on if they have a related theft offense. We'll talk about what that means, but this includes shoplifting, and it does not have a minimum of how much the person would have shoplifted. So if you shoplifted $10 worth of things, you are now subject to mandatory detention. Let's talk about it. Let's talk about who it affects, what powers it gives the Department of Homeland Security and the states, and how you can protect yourself when it comes to this act. I am U.S. Immigration Attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. This is a game changer, right? The Laken Riley Act is a game changer because it gives the Department of Homeland Security more power to detain people mandatorily, right? Mandatory detention basically means the U.S. government will detain the non-citizen until their immigration court case is over. Okay? Mandatory detention says if this person falls into the mandatory detention category, they will be detained. They will not be released. They will not be given bond, none of that. They will be detained until their immigration court case is over. Either they win the court case or they lose the court case. But regardless, they will be detained until that final decision is made. Now, how does the Laken Riley Act affect this? The Laken Riley Act requires the mandatory detention of non-citizens charged with theft-related crimes. Now, this expands what mandatory detention was. So mandatory detention is something that has existed as part of immigration law, but it was limited to certain crimes. Now, this Laken Riley Act is expanding what crimes fit into that. Now, it is including the following crimes: burglary, theft, larceny, shoplifting, assault of a law enforcement officer, crimes that cause death or serious bodily injury. Right? Doesn't matter the crime. If it causes death or serious bodily injury, you are now subject to mandatory detention. So you probably heard those crimes and you're thinking, well, if the person is convicted of those crimes, maybe they deserve to be detained. Well, hold on now. With the Laken Riley Act, it does not matter if you are convicted of the crime. It says that the Department of Homeland Security must take into custody non-citizens that are arrested, charged, or convicted of these crimes. All right. So conviction is just one option. If you are arrested for it, if you are charged for it, you can be detained. And then the other part is if you admit to committing these crimes without a conviction, right? You admit to it, but you were never convicted, you are also subject to this. The thing to keep in mind about people that are subject to mandatory detention is that Department of Homeland Security does not have discretion to say that this person should be released because, their case is still pending or whatever reason. They do not have that discretion. So it is one of those things that if you fall into, you are going to be detained for the duration of your case and you're not able to get bond because you are subject to mandatory detention. So here's why the Laken Riley Act is bad for non-citizens, because it does not care if you are convicted of the crime. It does not care if you are guilty of the crime. It cares that you are charged with the crime and that you were arrested for the crime, and then maybe if you're convicted of the crime too. But it does not care whether you're innocent or guilty as long as you were charged or arrested. So that's why it is so important that you know your situation. You're working with your criminal attorney, your immigration attorney, as your, if you're ever charged with any of these crimes. Also, remember that if you admit to committing any of these crimes, even if you're not convicted of it, you are still also subject to mandatory detention. So when I say you have the right to remain silent, please use it, right? Please use it. So here's a scenario that typically happens. Someone is at a store. They may have forgotten something in their bag, in their cart as they're leaving. They're stopped. They're like, oh, oh my goodness, I'm so sorry. I didn't know it was there. Oh my goodness, I'm so sorry that I took it. You just admitted to taking something out of the store that you did not pay for, shoplifting, right? So now, because you admitted to it, and when the officers come, you admitted to the officers. Now it's in a police report. Now you are subject to mandatory detention. Even if the officers do not charge you, even if you're not arrested, even if you're not convicted, you admitted to it. So now you're subject to mandatory detention. So when I tell you to remain silent, and when criminal attorneys tell you to remain silent, let this be your reminder to remain silent, okay? Do not admit to any crimes. Do not try to explain yourself. Wait for your attorney. Let your attorney speak for you. All right. So there's two parts to the Laken Riley Act. There's the part where it affects non-citizens, and then there's the part where it gives power to state attorney generals. So basically, the second part of the Laken Riley Act makes it possible for state attorney generals to sue Department of Homeland Security if the state attorney generals believe that a non-citizen's release or failure to detain has harmed the state. So if an attorney general sees that someone that should have been subject to mandatory detention was not detained, or someone that should have been subject to mandatory detention was released, that attorney general can look at whether its state has been harmed. And you're probably thinking, harm, what does that mean? It must be something major. Well, harm in this context includes financial loss exceeding $100. $100. So in this situation, if there's any financial loss and they can claim that it exceeds $100, they can sue the federal government. All right. So, and not only can they sue the federal government, the federal courts has to prioritize these cases over other ones. So it is giving states so much power to basically control Department of Homeland Security and how they enforce their laws. Giving state attorney generals this power is going to affect future administrations, because if, let's say, the next president wants to give more rights or more power to the Department of Homeland Security to make a decision on who should be detained and who shouldn't and all of those things, well, they may be limited on what they can do, because now they have to worry about being sued. All right. So it's really important to know the difference. This is an act. This is a law. This is not an executive order. This is a law. So in order for any future presidents to basically do away with this, Congress that passed this act has to pass a new one, right? Has to amend it. They have to do something. The president will not be able to just undo this, because it is not an executive order. That's why it's so important that we pay attention to who we have representing us in Congress. There were 12 Democratic senators that voted for this. Okay, 12. And for some reason, they did not understand the impact this would have on non-citizens. Because it's one thing to say that if you're convicted of these crimes, but no, it's not even looking at convicted. people. It's looking at charged people. It's looking at arrested people. It does not care, right? The Laken Riley Act does not care about innocent until proven guilty. It does not care about that. And that is one of the fundamental things about US justice system, is that you're innocent until proven guilty. But this is basically saying whether you're guilty or not, we don't really care. The fact that you're charged with it, you're subject to mandatory detention. So this is going to have an impact. All right? Because think about it, a lot of these crimes, like especially shoplifting, is typically like, even if the person is charged with it, it's typically done away with like restitution or something like that. That's not really a conviction for immigration purposes, but now whether you're convicted or not, you are charged, so you're subject to mandatory detention, right? So and the other part of it is like a crime like shoplifting, there is no limit, right? There's no guidance of, okay, is it shoplifting of amounts over this dollar amount? No, it's any shoplifting. So even if the stuff is $10 and you're charged with it, you are subject to mandatory detention. There's not a lot of limits, right? There's no limits on this. And also, it takes away the DHS's power to say, you know what, it was $10. It's only a charge. They're not convicted. Let's go ahead and release them pending their, court case. They don't have that discretion when the person is subject to mandatory detention. So it is given a lot. It's taken power away from Department of Homeland Security and given power to the state attorney generals. So now that you've heard all of that, what can you do? One, know your rights, okay? Remember, you have the right to an attorney, you have the right to remain silent. Use both of those, especially your right to remain silent. So what can you do as a non-citizen that may be, worried about this? You need to know your rights, okay? You have the right to remain silent, use it. You have the right to an attorney. And you want to make sure that you are following immigration policy changes because they are changing swiftly, and you want to stay up to date on those changes to make sure if it affects you, how it could affect you, and what you can do to protect yourself. And then finally, you want to seek legal help. Consult with an immigration lawyer to make sure, right, that you know what you qualify for on the immigration end of things, how you can be basically moving in this new state of immigration policies. Because like I said, it is changing so swiftly. So you want to make sure that you know your rights, you know what you could qualify for, what could happen if you get detained, all of those things. You want to know about it before it happens. And you want to have a family preparedness plan, okay? If you have a risk of being detained, because if you had any of those charges, arrested, convicted of any of those crimes, you have a higher risk of detention. So you want to make sure that you have a family preparedness plan and that you are prepared in case of a ICE detention. And again, if it's part of these crimes, it's a mandatory detention, which means you are most likely not going to be released until your immigration court case is over. So make your plans. So tell me in the comments how you feel about this bill, what you think about the fact that it is not just people convicted of a crime, it's people that are charged with a crime, arrested for a crime, even though they're supposed to be innocent until proven guilty. So tell me what you think about that in the comments. Feel free to subscribe for more immigration updates. And if you need legal help, you want to know what your options are immigration-wise, go ahead and schedule a strategy session with me. It is a free 15-minute session where we get to talk about your particular situation and figure out what your options are, if you do have options, and what steps you can take to make those options a reality. You can schedule that strategy session by going to my website, lilylegal.com, and clicking on Contact Us. There you can select the date and time that works best for you for us to chat.